I bet you're asking what the heck just happened in the Murdaugh case. I want to know too, and that's why I'm here with you today. My name's Christine Burke. If you don't know me, I'm a retired police detective and sergeant. I am a current law enforcement expert, which means I testify, I investigate, and I look into everything law enforcement specific. And I'm a forensic genetic genealogist. So I could gather that potentially something having to do with the police might have happened in this case, or been alleged to have happened in this case, or not happened in this case. And the attorneys outlined it, sent it to the judge, it went upstairs, and now we are back with a ruling for a new trial. So today, I'm going to walk you through, to the best that I understand it, what the attorneys originally asked for, and talk about why I feel, or what might have had to play with them getting it. So stay tuned. Thank you for being here. I'd love it if you'd like, subscribe, and share. I'd also love in the comments to know whether you found this interesting, whether you found it educational, and what you would like to see in the future. So enough of that. Let's get started. So this is a pleading that was filed in the South Carolina Court of Appeals. It looks like September 5th, 2023. Now, just so you guys know, we are in 2026. When I am recording this, it is May 13th, 2026. And the new trial was granted today, not from this document, from the judge's order. And I will get to that next. But let's see what they were asking for so we can see what they won on. Okay? So, this is a motion to suspend appeal and for leave to file motion for a new trial. So, the appellant, that's the person doing the appeal, asking for the appeal, Richard Murdaugh, is asking for a new trial based on after discovered evidence in the Court of General Sessions, right? So typically, and let me be clear here, I am not an attorney, and this is not my official opinion. If you'd like my official opinion, you could contact me and we can set up a business arrangement and we can do that. But I'm just here because I'm interested. I saw this come down today, and I always like to keep abreast of what's going on because we need to learn to do better if we've made mistakes, and it always helps the public to be educated about the court process. So they're talking about here after discovered evidence. So it sounds like after discovered evidence, after the case was finalized. Okay. Now, apparently, he was appealing on different grounds and is wanting to suspend that because there's time frames and all kinds of legal stuff involved to motion for a new trial. And that is attached here with some exhibits. Okay. And it says that this motion here and the documents relied upon are not contained in the record on appeal. Yes, okay. And Richard Harpootlian, I'm not familiar with the case, so I don't know all these folks' names, so please bear with me, seems to be the attorney for the defendant, for the appellant, okay, which is Mr. Murdaugh. Okay, and we've also got Margaret Fox and James Griffin for Griffin Humphreys. Okay, and they are in Columbia, South Carolina. Okay. All right. So here is Exhibit 1, the copy of the motion for new trial in Exhibit A through L. Here's the motion for the new trial. We don't have a date on this, okay? It says, Defendant Richard Murdaugh, through undersigned counsel pursuant to Rule 29B, hereby moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. Goodness gracious, that is an allegation, isn't it? Holy cow. So again, we want to go through the allegations, and then we want to see if we can find it in the order what the judges decided on, what they found credible, what they found not credible, or what they felt needed to be explored further. That's why this is so interesting, right? We get educated on better court process and things like that. So, specifically states Murdaugh's attorney, during the trial, the Colleton County Court clerk, Rebecca Hill, instructed jurors not to be, quote, misled by evidence presented in Mr. Murdaugh's defense. Now, let me tell you, like, jurors are like hands off. Like, don't look at them, don't talk to them. Like, that's why they wear their stickers. They're in their own area, like, because you can corrupt the entire process with even a whiff of something bad. So this, to me, working in the legal industry since I was a wee gal, this is scary times, okay? So, according to this pleading, right, this is not me saying this is this pleading, she told jurors not to be, quote, fooled by Mr. Murdaugh's testimony in his own defense. I didn't know that he testified in his defense. That's rare, so that's interesting to me too. Again, I don't know too much about this case. Miss Hill, the clerk, had frequent private conversations with the jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Miss Hill. Let me try to understand that. Okay, so it sounds like there was originally, and you guys may know more about this than me, there may have been a foreperson that was elected amongst the jurors. That's normally how that happens. And then somehow it required, again, this is what it sounds like, the court to appoint a substitution for whatever reason. Oh my goodness. Okay, it's getting crazier. Okay. During the trial, again, this is the pleading, so please don't infer that I'm saying this. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Whew, strong language here, folks. Ms. Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Man, oh man. This is like a movie, right? Like a movie. What do you call it? Reality TV and then some. Okay, again, these are allegations. These are allegations. They haven't been proven, okay? Ms. Hill, okay, we did the Facebook post. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. Now, I'm just thinking about this, right? I'm just spitballing here. Could they have felt that that was pressure? Because if she's the clerk and she deals with this all the time, you might get selected for jury duty. You're like, oh my gosh, how long is this going to take? Oh, I'm going to miss work. I'm going to miss my kids this, vacation, whatever. And you're like, oh, okay. So if she, the experienced person that deals with this all the time, could it be possible, or could it be a possibility even that some of the jurors thought, well, we better move this along? Because remember, she said, it makes you anxious. It makes you anxious. Maybe you think you're not doing it right, okay? Again, the attorneys say Ms. Hill did these things to secure, oh my goodness, I'm reading this as I'm recording this. I'm sorry. To secure for herself a book deal and media appearances that would not happen in the event of a mistrial. Goodness gracious. Miss Hill, I was going to say something I can't, betrayed her oath of office for money and fame. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. Oh my goodness gracious. Lordy, lordy. Here's the statement of facts. 1. Mr. Murdaugh was indicted for the murder of his wife Maggie and son Paul on July 14, 2022. His murder trial began January 23, 2023. The presiding judge was the Honorable Clifton Newman. The trial ran for 6 weeks, ending with convictions on the evening of March 2, 2023, and sentencing on March 3, 2023. The state, so prosecution, rested its case in chief, and the defense began its case on Friday, February 17, 2023. So the prosecution took about a month, it sounds like, and then the defense took maybe 2 weeks. Okay. Court was not held on February 20th, which was President's Day. After returning from the holiday, Miss Hill began to enter the jury rooms often. And now they are responding to this looks to be an affidavit of juror number 630 attached as Exhibit A. We can look at that. And I guess that this juror number 630 is going to explain how this happened or witness that or testify to that. As the defense began its case after February 20th, I'm assuming, Miss Hill told jurors, y'all are going, as the defense began its case, y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you. Now, if you're not familiar with the process, the state goes first and presents everything that they're going to present, and then they rest their case. And then the defense puts their case on. So I think what the attorney's trying to show here is because, remember, the defense started supposedly February 17th, but then we had the holiday on the 20th. And so they're coming back in, the jurors are coming back in, and she's saying now, not at the beginning of the trial, this is what, again, they are alleging, that she's now saying, right now that the prosecution is done and the defense has started, she's saying, y'all are going to hear things that'll throw you off. Don't let this distract you or mislead you. And if you guys have ever followed a trial, you know, you watch and you're like, oh, and then you hear something else, you're like, oh, and then you hear something else, you're like, oh. It's like a tennis match, right? And you don't know where the ball is going to go out. You don't know who's going to get the point. And then at the end, like, you have to watch it all the way to the end. And then you're like, man, well, this happened, this happened, this happened, this happened. And then you make your decision. Okay? So you have to have all the facts. So we have another affidavit here of juror number 741. The claim says, additionally, Miss Hill and juror number 826, the new jury foreperson, that would be interesting to see how that happened and why that happened, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Now, again, I'm not an attorney, but that is, even though it says jury foreperson, that's a jury person. That is a jury member, the person in charge of the jury, you know, within the jury. Sometimes they would go, and they're referring to these exhibits and stuff here. Sometimes they would go into the jury's room, single occupancy bathroom together. Four-person juror number 826 never said anything about the content of those conversations to other jurors. Ms. Hill even instructed jurors they could not ask foreperson juror number 826 about the conversations. 2 days later, on February 23rd, and continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began testimony, Ms. Hill told jurors, quote, not to be fooled, end quote, by the evidence Mr. Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. Again, more exhibit. Ms. Hill also instructed the jury to, quote, watch him closely, end quote, to, quote, look at his actions, end quote, and to, quote, look at his movements, end quote, which at least one juror understood to mean that Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, foreperson juror number 826 told the jury that Mr. Murdaugh was crying on cue. She also criticized the former foreperson, juror 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand because, quote, that is what the defense wants us to do, end quote. The defense wants them to hand a box of tissues. Maybe they're trying to infer sympathy or something here. Okay, I'm not sure. The next court day after Murdaugh's testimony, February 27th, Ms. Hill told Judge Newman about a Facebook posting she purportedly saw on the evening of Friday, February 24th, the day Mr. Murdaugh's testimony concluded. While perusing a Facebook group called, quote, Walterboro Word of Mouth, end quote. And then it looks like there's a draft transcript of an in-camera conference attached as Exhibit C. We can look at that. The post, purportedly by juror number 785's ex-husband, Tim Stone. Goodness, are you with me? Who's on first? Okay. Allegedly stated that, quote, his ex-wife was saying that she was on the jury and saying stuff about her verdict was going to be, end quote. Oh my goodness, golly gee. I don't know what it means. Judge Newman asked her to produce a copy of the posting. She could not produce a copy. Subpoena to Facebook. But according to Ms. Hill, a subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. And here's the language, apparently, allegedly, reportedly, from that apology post. Folks, I posted a ugly post yesterday to which I have deleted, and I kind of in a roundabout way directed it towards a certain person, and I would like to apologize to everyone who read it. That ugly for me to do, and yes, I let Satan control me, and I broke down and started drinking, and when I was drunk, I made that post, and I'm sorry. So it looks like there's a reference here to Behind the Doors of Justice. I don't know if that's a book she wrote. I mean, that sounds like either an article or a book or something. It looks like there's a Facebook post here, and I don't know if that's the original post or the apology post. The apology post states the initial post was already deleted on February 16th, so it would have been impossible for Ms. Hill to see the original post on February 24th. Interesting point. Again, these are the allegations made by Mr. Murdaugh's defense team. Mr. Stone, juror 785's ex-husband, avers in a sworn statement that he made no such post. Oh, man. And then we got what appears the affidavit of Tim Stone. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd, 2023 to March 2nd, 2023, which confirms he did not post the apology parentheses, the supposed original post, if deleted, would not be recoverable at this point under Facebook's retention policy, end paren. And that he, in fact, never posted anything to the Walterboro Word of Mouth Facebook page during the trial. And there's an affidavit here of Phillip Barber. The person who made the apology post is an unrelated person, oh my gosh, also named Tim Stone, whose Facebook profile picture is not juror number 785's ex-husband. Goodness gracious. I keep saying that. On February 28th, Ms. Hill questioned juror number 785 about the fictitious post on the, quote, Walterboro Word of Mouth, end quote, alone in her office in the courthouse. Affidavit of juror 785, Exhibit H. She told, going back to Ms. Hill, that someone had emailed her stating her ex-husband, Tim Stone, posted on the Walterboro Word of Mouth Facebook page that juror number 785 had been drinking with her ex-husband, and that while drunk, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Goodness, Exhibit H. Juror number 785 told Ms. Hill, that never happened, and that she had not seen her ex-husband in 10 years. Juror number 785 asked to see the post, but Ms. Hill would not show it to her. Ms. Hill directly asked juror number 785 whether she was inclined to vote guilty or not guilty. Juror number 785 had said she had not made up her mind. Oh, God. Can I say goodness gracious one more time? Later that day, Ms. Hill told juror number 785 that SLED, that's the South Carolina law enforcement, whatever, this is state law enforcement people, which is not good, and the Colleton County Sheriff's Office personnel went to Mr. Stone's house, and he confirmed he made the post. Oh my goodness. This is bad, folks. If this is true, this is bad. And this is the attorneys saying this. This is a fabrication by Ms. Hill. Ms. Hill told juror 785 she would somehow, quote, reinstate a restraining order juror number 785 previously had against Mr. Stone, which is something that Ms. Hill did not have the authority to do. Whatever that is about. Oh my goodness. Still later that day, Judge Newman examined juror number 785 regarding both the non-existent Facebook post and the tenant coworker email. Okay. Which they do. They will bring the juror in and talk to them. Juror number 785 described her interactions with Ms. Hill regarding the Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence. After she was dismissed, Judge Newman said, quote, sounds like me, oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me, end quote. Yes, this is irregular, folks. This is not good. And the attorneys say he was right to be concerned. But because they had the conversation, right, he dismissed her. Like, you can't have a whiff of things bad, right? Because then you get the appeal and the conviction overturned and stuff like this, right? So it says the next day, on March 1st, 2023, the jury visited Moselle, the site of the murders. During the visit, four-person juror number 826 and Ms. Hill walked off to have yet another private conversation. Well, in her book, I guess she wrote it, Ms. Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit to the Moselle property. And this appears to be the attorney saying that this is a quote from the book. While the jurors viewed the Moselle property, we could all hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew, I knew, and they knew that Alex was guilty. Folks, I mean, okay, I'm just saying we don't know that this is true. This is scandalous if true. It is South Carolina. I mean, and I used to live in South Carolina. I love South Carolina, but goodness gracious. I need a fan. I need a fan. Hold on. Whew, goodness. Okay. I'm from the South, y'all. Okay. Gonna have the vapors. Okay. That day, Judge Newman also held an in-camera conference regarding the tenant coworker email, whatever that is, in which he decided to revisit the Facebook post issue with Miss Hill. The court. This is the judge. Okay, well, let me see what Becky is talking about. I want to revisit the Facebook post that you mentioned yesterday. Oh, we have a number 1 here. It says, a coworker of a tenant of Juror 785 emailed the court on February 27th stating that the tenant said her landlord was a juror and had expressed an opinion when delivering a refrigerator to the property more than a week earlier. So apparently there's some accusation of, I don't know, I don't want to say leaking, sharing, or whatever, with this coworker tenant email thing. Okay. So Miss Hill says, right. And the court, this judge says, that's Becky Hill, the clerk of the court. Can you tell us about the Facebook post? Miss Hill says, yes. I think it was on Friday evening. Just for a brief moment, I perused Facebook, got on Walterboro Word of Mouth, and saw where someone had said that, well, it was the ex-husband of a juror, and he said that he noticed that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I just kept on scrolling because that was enough for me. I've gotten enough. She's the clerk, right? And the judge says, and how did you determine who he was talking about? Miss Hill, the clerk, says, when I heard there was an email on Monday, I figured the two went together if it was true. And what they're probably talking about is, the court takes great pains to make sure that the jury doesn't get tampered with, and they employ different measures and different things. And so it sounds like, I don't know, it sounds like Miss Hill, there was some mention of we've got a jury issue. There was an email, we've got a jury issue. She's thinking that it was this Facebook post. So the judge says, well, she's confirmed she has an ex-husband who she has 3 restraining orders out against. So, and Miss Hill says, right. So then we looked on Monday after you told me to try to go back and look for it, and we couldn't find it. I think she's referring to the Facebook post. But then we found out his name, and we found the post and printed it out where he said that he had put something up, but that he had deleted it at the time, and that he had put stuff out there that wasn't nice. And the judge says, he said he got drunk afterwards. And Mr. Murdaugh, whoever that is, I'm assuming maybe that's the prosecution. I'm not sure. It says something about the devil. And Mr. Harpootlian, the defense, says, didn't he say it was Satan in it? And Miss Hill says, yes. Or Satan was in it, yes. In all of the details, yes. And so the judge says, all right. And Miss Hill says, made me do it. So the judge says, okay, I just wanted to have that on the record. You're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got his information from. Miss Hill says, I don't. I can find it, though. Then there's an exhibit here, and then it says, these are the attorneys talking again, or the defense talking again in their pleading. But Miss Hill never saw any such Facebook post. She made it up. Further, she knew the quote apology post was not posted by juror 785's ex-husband. Juror number 785 showed Ms. Hill a picture of her ex-husband, which is not the Facebook profile picture of the other Mr. Stone's post about Satan. The next day, March 2nd, the day of the verdict, juror number 785 received a call from her ex-husband that she did not answer. The call upset her because Ms. Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror number 785 asked to speak with Ms. Hill. She told Ms. Hill she was scared. Ms. Hill told her that the, quote, Murdaughs probably, quote, got to him, meaning her ex-husband. Ms. Hill once again asked her opinion regarding Mr. Murdaugh's guilt. And we got the exhibits again in here. Juror number 785 told her that Creighton Water's closing was good, but that she still had questions. I'm not sure who that is. Ms. Hill asked what questions, and juror number 785 replied that she was concerned that no murder weapon was found. Ms. Hill then asked, well, what makes you think he's guilty? Juror number 785 said Paul's video at the dog kennels. Ms. Hill then told juror number 785 that everything Mr. Murdaugh has said has been lies and that I should forget about the guns. They will never be seen again, end quote. Ms. Hill then asked juror number 785 about the views of the rest of the jury, telling her that if the foreperson would, quote, just go in and ask for a raise of hands, this would be over and done with, end quote, and, quote, everyone needs to be on the same page, end quote. Juror number 785 went to the jury room and 10 minutes later was excused from the jury. In open court, immediately after her excusal, juror number 785 asked Judge Newman if he had spoken with the clerk of the court, referring to the conversation earlier that morning with Ms. Hill. Got some video here. Judge Newman responded, I have not spoken with her today, and that this is, quote, totally independent, end quote, of any, quote, conversation, end quote, regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the Facebook post. When the jury began deliberations that evening, Ms. Hill told them that this shouldn't take us long, quote, and that if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks as they had previously been allowed to do during the 6-week trial, but Ms. Hill told them they could not smoke until deliberations were complete. There were 6 smokers on the jury. Ms. Hill told jurors that after the trial they would be famous and predicted the media would request interviews with them. Now remember, this is the defense attorney's supposition. His what he's saying, not me. Ms. Hill even handed out reporters' business cards to jurors during the trial. Juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a network news show. If this is, I don't know this is true, this is just what they're saying. She traveled with jurors to New York City when they appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st, 2023. A last point about Ms. Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with the Colleton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary at the Colleton County Courthouse when it was closed for Confederate Memorial Day on May 10, 2023. The film crew had previously recorded an interview with Ms. Hill. On May 9th, Ms. Hill sent a memorandum to the film crew purporting to be a, quote, addendum to the contract. In it, she demanded that the film crew pay Colleton County a fee of $1,000 per day for the use of courthouse facilities and made a nonsensical statement about not having authority outside South Carolina that reflects a failure to understand the choice of law clause in the contract. Then she bizarrely added a handwritten demand. Again, this is from the attorneys. Also, in exchange for the use of the likeness of Rebecca Hill for an interview, a minimum of, there's a part that says it's unclear, 5-second video and audio clips will accompany the usage on the first reference. The book cover for the book, quote, Behind the Doors of Justice, The Murdaugh Murders, end quote, will be shown, and audio will include Becky's introduction as clerk of court for the Colleton County and author of the book. It says the film crew ignored her addendum as the contract had already been executed, but like her jury tampering during the trial, it was an attempt to violate South Carolina Code 8-13-700 subset A, which provides, quote, no public official, public member, or public employee may knowingly use his official office, membership, or employment to obtain an economic interest for himself, end quote. All right, now they're getting to the legal standard. And they're quoting here. Quote, a defendant in a criminal prosecution, so they said what happened. Okay, now they're saying kind of why it's bad legally, or the legal basis for it being bad, and the legal basis for, you know, why it needs a new trial. Quote, a defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial, it's a big word there, that's the word, jury. And in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence, end quote, State versus Johnson. That's a South Carolina case. That's the citation. Quote, when the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, end quote, the defendant has an entitlement to an evidentiary hearing. Barnes versus Joyner, okay, citing Remmer versus U.S. and Smith versus Phillips. So, even though Hill works for the court, the jury's the jury. The jury's the jury. So they need to, nobody should be interjecting in there. And then the attorneys put in here something, quote, this court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias, end quote, or in parentheses. So they continue. If the defendant proves the alleged contacts occurred, the prosecution bears the burden to show they were harmless. Okay. And he quotes, in a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial. Okay, so it's like the burden, it's automatically bad, okay, prejudicial to the fair trial. Okay, to the constitutional protections. It said, if not made in pursuance of known rules of the court, which means you can have contact about things, processes, and whatever, rules of the court, and the instructions and directions of the court made during the trial with the full knowledge of the parties. Like the judge says, get the jury, don't get the jury, ask them if they want lunch, things like that. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice and hearing of the defendant, that such contact with the juror was harmless to the defendant. Okay, then they quote Remmer here. I don't know if that might have come from the opinion in Remmer. It says the presumption is even stronger where the contact was made by a court official. All right. He says where there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, ... A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict, end quotes. State versus Cameron, quoting Holmes versus U.S., blah, 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 blah. So now the argument. Okay, this is again what the attorneys are saying. A state official, Rebecca Hill, the elected clerk of the court, had extensive private communications with members of the jury during trial. This allegation is supported by sworn affidavits of jurors and a witness to juror interviews, testimony at in-camera proceedings, and other evidence, including Miss Hill's own book. The court must therefore hold a Remmer evidentiary hearing. He cites Smith, Barnes. If the allegations are proven at the evidentiary hearing, then under binding appellate precedent, the court must grant a new trial unless it, quote, clearly appears that the subject matter of the communication was harmless and could not have affected the verdict, end quote. And then they're quoting Cameron. The subject matter of Miss Hill's communications was the evidence being presented at a trial by the defense. These improper comments and efforts to influence the juror's verdict vitiated the sanctity of the jury's deliberation and Murdaugh's sacrosanct right to a fair and impartial jury. The court therefore must grant a new trial if the allegations are proven. In a 6-week trial, people will talk when they should not. They will say things they should not say. Mistakes will be made. The participants in a trial are fallible human beings. Lawyers combing the proceedings after the fact will always find they made mistakes and errors. If that were enough to force a redo of the trial, no verdict would stand and trials would be repeated forever. To avoid that, courts properly strain to find that mistakes during trial are, quote, harmless, meaning they did not change the result. But the issues now before the court are not the ordinary and inevitable mistakes that occur in any trial. The issue here is that an elected state official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury, to secure financial gain for herself. Where a state actor engages in private communication with the jury about the merits of the prosecution, the verdict is impossible to sustain. For example, in Parker versus Gladden, a bailiff told a juror in a murder trial, quote, that wicked fellow, he is guilty, end quote. The Supreme Court of Oregon held the statement did not require a new trial because it was not shown the statement prejudiced the outcome of the trial. Okay, how do you know that? That's my question. The U.S. Supreme Court reversed, holding, quote, the evidence developed against the defendant shall come from the witness stand in the courtroom, in a public courtroom where there is full judicial protection of the defendant's right of confrontation, cross-examination, and of counsel. We have followed the undeviating rule that the rights of the confrontation and cross-examination are among the fundamental requirements of constitutionally a fair trial, due process. So the Supreme Court said, no. So coming back to this case, it says, in this case, the court has declared on the record that, quote, the verdict that you've reached is supported by the evidence, circumstantial evidence, direct evidence, all the evidence pointed to only one conclusion, and that's the conclusion you all reach now, end quote. And they reference a camera. The court has therefore foreshadowed the outcome of any, quote, harmless error analysis. So that's an interesting point. So I think what he's saying there is because the judge said, you've looked at everything, so you only have one conclusion. So there can't be any harmless error. But he says the rule for deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. If that were the case, the court would sustain a guilty verdict even if she coerced the jury to vote guilty at gunpoint, because in the court's opinion, quote, all of the evidence pointed to only one conclusion, end quote, the guilt of the accused. If the strength of the evidence against the accused in the eyes of the court excuses deliberate jury tampering by a state actor, the state actor because she worked for the court, the clerk, the result is a directed verdict for the prosecution, a structural error. And he says that can't be the law. And he cites Nader versus United States, and where Justice Scalia concurred. And he mentions here, noting that, quote, even if the judge certainly reached the, quote, right result, quote, a directed verdict against the defendant, ... would be per se reversible, no matter how overwhelming the unfavorable evidence, end quote, because, quote, the very premise of structural error review is that even convictions reflecting the, quote, right result are reversed for the sake of protecting a basic right. Okay? Kind of like, and this is going to be a little like inflammatory, but I want you to take it how it is. The court process, the due process has to trump right? Because we all have to have the right to due process. I think that's what he's trying to say there. He said, instead, the law requires the, quote, subject matter of the communication to be harmless, quote, clearly harmless. He cites Cameron. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. Our Supreme Court recently made this point in State versus Green. In Green, during jury deliberations, a juror asked a bailiff, quote, what would happen in the event of a deadlock? And he responded, the judge would likely give them an Allen charge and ask if they could stay later, end quote. Citing a case. Allen is probably some precedent, right? The Court of Appeals held that the bailiff's comments were presumptively prejudicial, right, on the more so prejudicial because of his official position, but that the state rebutted that presumption by showing for various reasons that the remark did not in fact influence the outcome of the jury's deliberations. So I think what he's saying here is that the Court of Appeals said, like, it was presumptively prejudicial because it was made by the bailiff. So they're trying to say here, well, if this court in this case said because it was the bailiff, it was already presumptively prejudicial, then, right, it should be presumptively prejudicial in this case, right? So he says the Supreme Court upheld, but modified the decision to correct the Court of Appeals reasoning. The communication was not presumptively prejudicial because the subject matter of the communication was harmless. So it says the bailiff's actions here, though improper, did not touch merits, but dealt only with the procedural question of how the judge might handle a jury impasse. He says, in other words, a bailiff telling the jury that if it's deadlocked, the judge will instruct to keep them deliberating is improper, but likely harmless because the subject matter is procedural or logistical rather than directly talking about the case, right? So he says here, telling the jury not to believe the defendant's defense or his testimony when he testifies is exactly the merits of the case. So they continue saying Ms. Hill's extensive, deliberate, and self-interested jury tampering far exceeds the simple bailiff mistakes that forced a retrial in Cameron, where, quote, a bailiff's misleading response to a juror's question about sentencing options compromised the jury's impartiality because it left the impression that their verdict could not affect the trial court's sentencing discretion. And then he refers to Blake by Adams versus Spartanburg General Hospital, where a bailiff told a juror that, quote, the trial judge did not like a hung jury and that a hung jury places an extra burden on taxpayers, end quote. Okay, so then they could be thinking about, oh my God, we're going to cost all these people this money, or I'm going to cost myself this money if you're a taxpayer. He talks about State versus Green. So he says, unlike the honest mistakes of the bailiff in those cases, Ms. Hill had many private conversations with jurors about the merits of the case. She asked jurors about their opinions on Mr. Murdaugh's guilt or innocence. She instructed them not to believe evidence presented in Mr. Murdaugh's defense, including his own testimony. She lied to the judge to remove a juror she believed might not vote guilty. And she pressed her jurors to reach a guilty verdict quickly so she could profit from it. Each of these actions violated Ms. Hill's oath of office, her responsibility to the citizenry and the judiciary of the state, and Mr. Murdaugh's constitutional right to a fair and impartial jury. He says the law applied to these facts requires a new trial. Okay, so he submitted that. And we have all these exhibits here. Okay, so I don't think we need to go into all these, right? We know that it was granted, all right? And so now he's going to get a new trial. I will find the order that the judge, because I want to see what the judge based it on, right? This is good education for all of us. And we'll see what the judge based it on. So thanks for being here. Share any comments below. I would appreciate it if you would hit the subscribe button. And, thanks for being a part of the channel. I'll see you next time.